Hello, this is Matt on the Moon Family Sedan channel. We're going to see how this goes because I am currently sick, which is why I put out absolutely no content yesterday. I don't know what I have. I don't know if I caught the Rona again, if I've got a little touch of the flu, but I can tell you that I've been laying in bed since all of yesterday, since yesterday morning, and oh my god, I am bored. I cannot stand streaming one more single thing, so I'm going to try and get through sharing some information on some of the latest crypto stuff here. I feel like my voice isn't quite to where it should be, but in case anybody's wondering, that would be why. Although my girlfriend says that it sounds normal, I'm not sure I completely agree with that. Or maybe when I spoke with her earlier, maybe it did. But anyway, I just thought I'd let you know, because I think I probably sound a little bit off right now. But I'm a bit more with it mentally than yesterday, so I'm going to give this a go. And if I end up coughing up a lung, then I just won't publish this damn thing. So we'll see how it goes. But I do feel, mentally better than I did yesterday. Certainly, it's just, I got the whole achy thing and it chills constantly and just no energy whatsoever. But right now, I'm coming off a big old batch of sleep, so I'm feeling all right. So again, we'll see how this goes here. But I apologize if I sound like complete and utter garbage, more so than normal. But here's a headline from crypto media outlet U Today. Ripple Ally v SEC. January 30th might be most significant crypto hearing to date. And so Attorney John Deaton ends up pointing out how truly dangerous the SEC's proposed remedies are in the SEC v. Library lawsuit. And, they, I think too, so this is the way that they're approaching this. Don't be surprised if they attempt to be just as harsh in the SEC v. Ripple case. If we get to the point where Ripple actually loses and we're seeking remedies, which is where we're at in the SEC v. Library case, could be disastrous in terms of what they're going for if they're actually granted it. But look, they're literally the SEC assets. They literally seek to have the power to prevent secondary market transactions. Think about that. If granted, that doesn't mean that the SEC would suddenly have special permissions over the blockchain, the LBC blockchain, but it does mean that they'd be able to legally attack regular people for using the blockchain, because that'd be a violation, right? Even if whoever they end up in theory attacking in the future, even if that individual never ends up using it for anything related, even loosely, to investment purposes, still they'd have something to go on. That's freaking scary. So I'm going to share with you Attorney John Deaton's latest comments on this very topic. And this is what's coming for the rest of crypto if we don't stop this. This will be coming in the SEC v. Ripple case next if things don't go well. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And so here it is from Attorney John Deaton, and he shared this literally just yesterday. He said, the January 30th hearing regarding Library's motion to limit the SEC's remedies is arguably the most important crypto hearing to date. And I'll just pause to note, I think everybody's caught up to speed, but it's kind of important, so I'll just pause and note. The SEC did defeat Library in November, and we're now at a point where we're waiting to find out what's going to happen in terms of penalties. It's the remedies phase of this, which just means penalties. And my gosh, what the SEC is going for is completely unreasonable. But we're going to find out soon whether to get their way. I'm still concerned about the judge in this case. But anyway, the SEC is seeking disgorgement from a non-party, but also read the SEC's proposed language for the permanent injunction. The proposed language could theoretically allow the SEC to reach into the secondary market and prevent transactions from people who are only users of the platform who never acquired LBC for investment reasons. Now pause and think about this. Imagine that this is the approach that was taken regarding the actual Howey case back in the 40s. So it was found that there were securities violations regarding W.J. Howey Co., but imagine if you just want to buy a damn orange at a supermarket. Now the SEC can actually come at you for that transaction on a secondary market. Just go to the damn grocery store. That's exactly what we're talking about here. Attorney Deaton continues. For example, the SEC could never satisfy the Howey test as it applies to Naomi Brockwell's use of LBC. And pause a note here, Attorney John Deaton did file an amicus brief in the Library case, actually, after Library lost, pertaining specifically to the remedy/penalties phase of the case. And it was written on behalf of Naomi Brockwell, who is a crypto media influencer, I guess, however you want to say. I'm not a big fan of the word influence, but I get whatever. It's what people know. So anyway, I guess crypto media influencer, I guess it's fair. But anyway, she ended up acquiring LBC by using the platform, but she's never bought it and she's never sold it. In fact, she didn't even know it had a monetary value at first. So attorney Deaton with another attorney, I think it was attorney, starts with a G, it was like Gannon or something like that. There's another attorney that worked with attorney Deaton on this and filed an amicus brief pointing out, hey, this is nonsense. What about secondary markets and a whole bunch of other stuff? I did a full video breaking that down when it was newer. But anyway, Attorney Deaton then says, the SEC stipulated that there are many LBC holders who only use LBC for the platform, never considering it an investment, yet the SEC refuses to issue a no-action letter. This is why, on behalf of Naomi Brockwell, I filed the amicus brief and filed a motion to be admitted pro hoc on the issue. This case, not getting a lot of industry attention, i.e. there aren't 15 amicus briefs in support of LBRY like in Ripple, the following is at issue. Number one, the SEC is inappropriately seeking punitive disgorgement in a non-fraud case. Judge Knepern in the Ripple case stated that the lawyers at the SEC lacked a faithful allegiance to the law and, despite the law, framed legal arguments based solely to advance its desired goals. It appears the SEC is doing the same thing in LBRY, even though the SEC won. LBRY, like Ripple, is a non-fraud case. A strict Section 5 violation, failure to register LBC sales. Ask yourself, why is the SEC seeking disgorgement in this non-fraud failure to register case? The SEC won summary judgment versus Kick, but didn't seek or ask for disgorgement. And so what he's referencing there, I'm sure most of you are familiar at this point, but just to be clear, there was a case dating back a few years or so in which Kick Interactive, which had the Kin token, they were defeated, but they were actually allowed to continue existing. And they actually, if they were ever going to sell any more of the Kin tokens they held, they just had to basically let the SEC know, and there was some sort of time frame where they had to hold off from selling. It might have been like 30 days if they were going to make a sale. I can't remember all the specifics. But the point is, they weren't trying to kill Kick Interactive. They're trying to utterly destroy LBRY and the LBC token. This is the new harsh approach they're taking to crypto. And I'm sure that, I'm a huge fan of like the way that LBRY has just been an honest voice about what's going on, how disgusting the SEC is. Although I don't suppose in the remedy portion of this trial that being as forthright as LBRY has on social media has necessarily helped them. Now, they're right, so this is not some sort of harsh critique against LBRY. I'm a fan. But the asshats at the SEC, oh my gosh, they are petulant children. And they got butthurt about the things that LBRY is saying about the SEC publicly and all the disgusting stuff they did because they're sociopaths, basically. And I think as a result of that, it's probably made them go a little bit more in guns a-blazing for the remedies portion of what's going on here. And so again, Attorney Deaton said the SEC won summary judgment versus Kick, but didn't seek or ask for disgorgement. Yeah, but they're asking it for LBRY. More troubling, SEC alleged LBRY used all the funds raised by token sales to build out the platform and technology. Despite making such claims, the SEC is now claiming all the token sales were profits. The SEC, again, is ignoring applicable law. The Supreme Court in Liu v. SEC, which is from the year 2020, requires the SEC to deduct any of LBRY's legitimate business expenses if the money from token sales were used, as the SEC alleged, to build the business. That money was then legitimate expenses. It is clear the SEC is being punitive. The question is why? Is for LBRY specific reasons or crypto in general? That's a good question, Attorney Deaton. And again, I'm still wondering if a notable part of this has to do with the fact that LBRY was very vocal about how disgusting the SEC is, because they're sufficiently petulant to, behave nefariously. Additionally, I wouldn't put that past them at all. But seriously, the idea that you can have these legitimate business expenses in a non-fraud case, and then also claim that they're profits if they're spent, and it's clearly not profit. And there's precedent to indicate what they're doing is completely wrong here. Attorney Deaton continues, number 2. The second major issue is that the SEC is also seeking disgorgement against a non-party entity. This has huge implications and could set a very bad precedent. So pause to think about that. The SEC, they won against LBRY, but there's another party in there. And I believe what you're referencing here is Odyssey. I'm pretty sure, anyway. So Disgorgement from Odyssey, which is not a party named in the court case. How the hell does that work? That sounds ridiculous. Imagine somebody being convicted of something also applies to somebody that was not tried in court. That doesn't sound quite right to me. Number 3, the language of the proposed permanent injunction, which is provided above, coupled with the SEC's absolute refusal to distinguish secondary market sales or even transactions by users, demonstrates the SEC's intent to expand its jurisdictional reach into the secondary market. All the above and more is why I said the January 30th hearing is arguably the most important hearing to date, not to hate. So a lot of precedent getting set here. We're living through what will undeniably prove to be a very important part of crypto history. We got front row seats, and at times it looks very ugly. I'm still optimistic, big picture for the future, but wow, what a mess out here. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.